Hi, my name is Patrick O'Brien, and I'm coming today with a short video on petty larceny and shoplifting in Virginia. I want to start here because you are probably watching this video in the middle of a total freakout, because you are terrified. You have ruined your life and will forever be branded a thief because of this charge. Let me hopefully calm things down a little bit. Depending on your circumstances, especially if this is the first time you've ever been charged with an offense, it is highly likely we will be able to get the charge dismissed either on your initial court date or through a deferred disposition. A deferred disposition is when, even though the court finds there is sufficient evidence to find you guilty, will give you an opportunity to get the charge dismissed after a period of time and the completion of certain conditions. Our clients are often able to expunge these charges and move forward without this stain on their record. Some initial information. Petty larceny and shoplifting are often used interchangeably to describe the acts of taking items from a store without paying for them. We say petty larceny because we just love Latin in the Commonwealth of Virginia, and we are sticking to those guns no matter how dead the language is. Some things to know. Generally, in Virginia, a court will want to know if the items in question were taken past all points of sale. Put simply, did a person pass by all the cash registers without paying for an item? One twist on that. They don't actually need to prove a person passed all points of sale if there was some proof the person intended to steal the items. For example, if a person removes price tags and places an item in their coat, this could be sufficient evidence to find someone guilty. The amount of trouble you are in is a bit of a sliding scale. One analysis point is jurisdictional. Generally, the more rural the county in Virginia, the more seriously they take theft crimes. The second analysis point is value. Courts and prosecutors will take the theft of an Xbox a lot more seriously than the theft of a candy bar. Lastly, your prior record is really important. If you have never gotten charged and have a totally clean record, your outlook is a lot sunnier than someone who calls me and has 2 prior larcenies on their record. How do we combat these charges? Like every case at Dischley Law, we are going to attack it from 2 angles. The first is determining whether the Commonwealth can prove the charge. We are going to review the discovery with you and determine whether there is evidence you actually took these items or if this was just a big mistake. The second angle is mitigation. With a combination of community service and shoplifting prevention classes, we work with the prosecutor to achieve optimal outcomes. It is important to know that completing mitigation is not an admission of guilt, but rather a way to make all parties comfortable that such an event will never happen again. With these techniques, we are often able to get these charges dismissed and eventually removed from our clients' records. If you have any questions or are charged with petty larceny and shoplifting and want to discuss your case, please feel free to reach out to us at Dischley Law, and we will be of service. Thank you.